This is a guide to the personal injury claims process in Ireland. Under Section 8 of the Civil Liability Act 2004, this is called a letter of claim. A person pursuing an action should serve notice in writing to the other person within 1 month of the date of the accident of their intention to pursue this course of action. If you have been injured due to the negligence of another and wish to pursue an action to recover damages, you must begin this action within 2 years of the accident date in question. This is a strict legislative rule which has some exceptions for exceptional circumstances. The rule is specified in the Statute of Limitations Act. There is an exception title date of knowledge under Section 2 of the Statute of Limitations Act 1991. One must submit their application within the statutory permitted timeframe, or it can be deemed statute barred. Preservation of evidence. It is very important to retain all evidence. What the evidence is will change on a case-by-case basis. Form A. This is the application form to the Injuries Board. It is not a complicated form to complete, but it must be completed correctly. The correct factual details must be specified on the form with the correct legal title of the party responsible for the accident. Searches should be conducted to ensure one has the correct legal title of the respondent. The application to the Injuries Board can be submitted by post or online, with the application's administration fees being €90 or €45, depending on whether it has been submitted by post or online. A medical report must be submitted with your application, and this can be completed by your doctor on what's called Form B. Your doctor will likely know about Form B and have prepared a report previously using this document format. The medical report will include information regarding accident details, injuries sustained, medical history, complaints, clinical findings, and possibly prognosis. The Injuries Board will not accept the application without a medical report. Registration. Once the Injuries Board have received the application, they will furnish the Section 50 confirmation letter, which is very important, as it acknowledges registration of the claim with the Injuries Board, and you will receive a claim number. This acknowledgement letter will be dated, and so is important for comfort that the claim was registered within the required time frame. Section 13. Notice the Injuries Board will then send notice of the application to the alleged wrongdoer, and he or she has 90 days to consent or reject the Injuries Board making an assessment. If the respondent party does not respond to the Injuries Board within the required time frame, they will proceed to deal with the application. The Injuries Board will after this period begin their assessment if the alleged wrongdoer does not reject this outright. In that case, court proceedings can begin. Medical appointment. The applicant will be required to attend an appointment with a doctor engaged by the Injuries Board. Special damages. Special damages in personal injury cases are financial loss items. A document will be provided to the applicant for this, and this document will need completion. 9-month period. The Injuries Board should make their assessment within 9 months of receiving the alleged wrongdoer's consent to assessment. Once the assessment decision is made, the alleged wrongdoer is given 21 days to accept the award. The applicant is given 28 days to accept the award. The Injuries Board can seek a time frame extension and seek consent of the applicant for same. Decision. If all the parties agree to the Injuries Board making an assessment of the application, then the Injuries Board will proceed to make an assessment of the claim. This is a monetary sum. The Injuries Board make their decision based on what's called the Judicial Guidelines, the medical reports on file, and the special damages, i.e. out-of-pocket expenses, of the applicant. Once the Injuries Board make their assessment, i.e. their decision, they write to the applicant and the party responsible for the accident and await a response from both parties to establish if they agree to the board's assessment sum or not. If the injured person and the other person, respondent, both accept the award, then the Injuries Board will make an order to pay. If one party does not accept the award in question for whatever reason, the matter has not been agreed to, and the Injuries Board then won't grant an order to pay. How are personal injury claims calculated? Personal injury claims are assessed by the Injuries Board with the guidance of the Judicial Guidelines for general damages, and the Board will also consider the applicant's out-of-pocket expense losses, such as medical bills and earnings losses. Damages in legal cases of this nature are divided into two groups, namely general damages and special damages. Special damages can be loss of income, medical consultations, treatment fees, damage eye loss of car hire, medication, vehicle towing, travel, physiotherapy, damage to property, or other expenses incurred relevant to the accident. General damages are calculated with respect to consideration of the pain and suffering sustained. The nature and duration of the injuries will be examined together with the effect on one's life. Each personal injury claim is dealt with on an individual basis. However, the Judicial Guidelines do provide guidelines regarding a potential range for compensation for a particular injury. Court process. At the outcome of the injuries board process, once a decision is made, the applicant and respondent must agree to the assessment. In that case, the matter is concluded. If either side do not agree to the outcome, the injuries board consider the matter too complex or for another reason can issue document titled authorization. In this circumstance, the application must proceed to court if they want to advance their case. Cases of this nature come before the District Court, which has a jurisdiction up to €15,000, Circuit Court up to €60,000, and High Court claims exceed this then. If you have any questions, our contact details are 01 5461 or 052 612 1999, or our email address is info@clearysolicitors.com, personal injuries. In contentious business, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement.